Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. Today, September 5th, 2025, several documents appeared on the public docket in Idaho versus Kohberger, and this is consistent with Judge Stephen J. Hippler's rulings of September 3rd, 2025, stating that certain items that have been under seal from public disclosure in the case would be released either completely unredacted or redacted for the reasons that are given in the court order. This was filed on the 13th of June, 2025. It is a sealed defendant reply to state's objection to defendants' offer of proof regarding alternate perpetrators and defendants' evidence in support of offer of proof regarding alternate perpetrators. So just before we get into what this filing says, I wanted to point out that I'm taking things out of order than what I usually do. What I usually do is if there's a motion and then a response and then a reply, those are the briefings. I will go in sequence. Present the motion to you first, then the response, and then the reply. Those are the briefings in any matter that you've seen in Idaho versus Kohberger, whether they're motions in limine, whether they were motions to suppress evidence, or in this case, it was relative to the defendant's evidence in support of offer of proof regarding alternate perpetrator. But I think it's important to bring this one to your attention because it has some information here that I don't believe the public had official notice of before. So let's get started. What does this say? It reads as follows. Page number 1. Comes now Brian C. Kohberger by and through his attorneys of record and hereby responds to the state's objection to defendants' offer of proof regarding alternate perpetrators and defendants' evidence in support of offer of proof of alternate perpetrator, filed on June 6, 2025. In parentheses, state's objection. It's also really state's response, responding to the defense motion, and now comes the reply to the response or the objection. That's sequentially what you'll see in briefings. Next paragraph is legal analysis and legal support that defense is producing in support of their position here. All of this has to do with federal law. In fact, the federal Constitution and the amendments thereto, the Due Process Clause, is extremely important. 14th Amendment, it essentially stands for the proposition that proceedings need to be fair. There needs to be a fairness component built into proceedings. In the next paragraph, defense counsel discusses what had come before the court's ruling on the defendant's offer of proof regarding alternate perpetrator. Going into this second full paragraph of 2, if you go to the middle part, it says the state has listed, and there's almost a full line of redacted material. It looks like this is more than one person, and it seems to confirm it. Next few words. The state has listed this long redaction as trial witnesses, plural, not one. The state has also disclosed and labeled exhibits that it intends to use at trial, which includes the names or actual video of these witnesses. And these exhibits include, and now there's another long section of redacted information describing what's apparently in these state exhibits. Then defense counsel says, each of these alternate perpetrators identified by defendants and listed as witnesses by the state are more closely tied in knowledge, opportunity, and possible motive to the crime than Mr. Kohberger. All four of the alternate perpetrators are linked circumstantially or directly to the crime. Moreover, given Mr. Kohberger's expert disclosures that more than one person committed these crimes, other evidence supports the defense theory that Mr. Kohberger is not the person and the crimes were committed by more than one person. The defendant's offer of proof in part arises from the state motion in limine regarding alternative perpetrator evidence filed on February 21st, 2025. And then on page 2 of that motion, the state argued, in this case, during the course of the investigation, literally thousands of tips regarding possible perpetrators were received by law enforcement, with the exception of information regarding the defendant. None of the tips were substantiated. Defense counsel then says, while it is true that there are thousands of tips somewhere within the range of 45,000 to 75,000 tips, and they continue daily, the state has chosen to present evidence of investigations into the specific named individuals and the conclusion that the state has ruled out these potential perpetrators. The state's purported diligence in ruling out possible perpetrators, especially those with close connections to the victims, is an issue that the state is putting front and center in trial at its own case in chief. Mr. Kohberger has a right to confront this evidence. State argues the evidence submitted in the offer of proof is inadmissible. As explained above, much of it the state seeks to admit in its own case in chief. And then, more importantly, citing to Chambers versus Mississippi, the U.S. Supreme Court held that a defendant's constitutional rights to a fair trial and to present a defense sometimes requires admission of evidence of third-person culpability, even in the face of evidence rules that would exclude it. So, we're seeing here now where I believe the defense is pulling together what it said above, that due process in the 14th Amendment and a right to confront witnesses against you in the 6th Amendment would supersede any rules of court, and alternate perpetrators is governed by a rule of court, and it's cited to in State versus Meister. Going down, fairness and trustworthiness of the evidence are important. Mr. Kohberger proffer includes details that allow the court to see there is trustworthiness to his basis for naming 4 alternative perpetrators. The police reports and tips, exhibits, and the offer of proof are documents that provide basis to show a link to the case that is more than speculation and grounds that explain the subject of cross-examination or direct examination of witnesses. While the tips themselves may be inadmissible, they are evidence that this court must consider in determining if there is a link and more than mere speculation. Then the defense cites 2 more federal case law in support of their position, and then at the bottom of page 4, towards the bottom, with respect to the entire paragraph is almost redacted. That is not a thorough investigation. That is not suspect elimination, as the state argues. Mr. Kohberger did not produce these suspects. The state did, and in some instances continued to investigate them or simply stopped their investigation, ignoring evidence that there was more than one perpetrator. Prosecutor Bill Thompson, said he could not rule out two perpetrators from the very beginning. Mr. Kohberger's offer of proof was not an exhaustive list of all the evidence disclosed in this case. That points to 4 alternate perpetrators. In fact, the state's opposition disclosed, and then unfortunately there's several lines of redacted information. By listing these alternate perpetrators on their witness list and by listing various exhibits on the exhibit list which pertain to these individuals, the state has opened the door for Mr. Kohberger to confront this evidence and cross-examine state witnesses. Mr. Kohberger suspects that the state has listed the 4 alternate perpetrators as a ruse to make it look as though they will put the 4 males on the stand to deny their involvement. These witnesses must be confronted, and therefore, if state seeks not to call them to the stand, but instead uses lab reports to portray elimination, the door is open to confront that evidence, and Mr. Kohberger should be allowed to call the alternate perpetrators and other witnesses to show their connection to the crime. How each piece of evidence becomes admissible at trial depends on how the state offers it, triggering Mr. Kohberger's right to confront such evidence. Mr. Kohberger must be allowed to develop this evidence, and a ruling excluding or limiting this area of inquiry at this point would be premature. So let's look at what, in giving an opinion, speculation, based on what is stated here. What has been stated here first, in addition to Mr. Kohberger now disclosing that there has been evidence produced by expert theory that this crime was committed by more than one person. Secondly, Mr. Kohberger calls the state's citing of the 4 people who he has cited as alternate perpetrators on their witness list for trial as a ruse, as pretending that they're going to ask these people about their potential involvement in the case. If the state does not call these witnesses who Mr. Kohberger has identified as his alternate perpetrators, the defense can't cross-examine. So a lot of information has been disclosed in this reply brief. It continues on toward the end, bottom of page 5, U.S. Supreme Court ruling in Chambers allows for the admission of this evidence. State agrees at a minimum to this confrontation in its objection. The court should allow Mr. Kohberger to present alternate perpetrator evidence. And this is signed 13th of June, 2025. Elisa Massoth as counsel to Mr. Kohberger. So we've learned quite a few bits of information that the public was not aware of, in my opinion. If you have any thoughts, any comments, any feedback that you would like to make relative to this issue, please leave it here until next time. This is Kathy. Thank you for joining us today.